Very good morning to all the students who are appearing for CA intermediate exams in the month of May 2026. BRICS Academy is now giving you something corporate law sections revision. Uh, the importance of sections are very important. Some students are thinking, okay, I know the concept, so I can answer all the concepts, so I can score good marks. Yes, even without writing sections, you will definitely get 40 marks. Yes, do not ignore these lectures. These are given for free for both BRICS and other students. The videos are made public. Make sure you use it for revision. Okay, so I'm not going to go very in detail into certain sections, but certain sections I want to go very in detailed. The first and foremost important thing is in CA Inter corporate law, that is 60 marks paper. So questions are 99.9% or case law questions or practical questions, scenario based questions. Even if you look at MCQs also, it is scenario based questions. So especially when it comes to case law questions, the first paragraph of your answer has to be with the section, and try to remember all these sections. That is section 1, section 1 to 148 and section 379 to 393. That is always advisable if you really want to score 60 plus in corporate law. I mean corporate law and other laws. Out of 60 marks, trust me, you can easily score MCQs if you have a concept of sections, because end of the day, law is always taught with the help of sections. Do not listen to anybody. Do not listen to anybody unless and until you write the provision for law, especially company law. I'm telling you, you're not going to get good marks. So be very careful. Spend some time every day, 15, 20 minutes. I will finish all the sections, section 1 to section 148 and section 379 to 393, the 11th chapter in your company law, mostly in 6 7 sessions. So every time 20 30 minutes, you just spare time and listen to these classes. It will help you a lot, and it'll add something for your revision. Okay, do not ignore. Company law 2013 has got 470 sections. How many sections? 470 sections. And it has got 7 schedules, and it has got 29 chapters. And plus, we have to read rules of 2014 and different rules. Rules are usually released by Government of India. When the section is not very clear, or when the section doesn't explain everything, Government of India must have passed rules through Parliament. Regulations are generally passed by the bodies, regulatory bodies, like whatever comes from SEBI, we generally call it as regulation. In addition to this, Government of India will release a lot of notifications. And at the same time, when you are studying law subject, you have to also understand that there are some illustrations in the textbook itself. So illustration is a part of law. If in case you fail to read illustration, 101% it is pretty sure that you did not understand that section completely. So do not miss any illustration, because illustration is an additional concept that is explained in the law when it comes to sections or anything. The next very important thing, some sections you will also have explanation part, explanation 1 2 etc. That means if you are not reading illustrations, if you're not reading explanations and examples, you may not understand complete section. But if you don't understand complete section, there's every possibility you will miss out some basic concepts in case law questions. You must be very very perfect in spontaneous answer writing. There is no watertight compartment, there is no fixed platforms, fixed model, this is how you have to write the answer. But generally speaking, looking at the ICAI Institute illustrations and answers, we can come to conclusion you have to divide the answer into 3 paragraphs. The first important paragraph is you need to understand the concept involved in that case law. Then you have to start writing with the section as per section, so on. So in Company Law 2013, this is the concept. Because if the question is for 5 marks, 101%, for the concept itself, you will get around 2 marks. And the second paragraph, you have to explain very clearly what exactly is the dispute in the case law. And the third paragraph, you have to come to a conclusion and explain the solution. So if you properly write the answer, first paragraph, second paragraph, third paragraph, first paragraph, number of lines will be more because you got to explain the concept. Second paragraph maybe little less, then third paragraph completely less. Suppose first paragraph, if you have written some 6 or 7 lines, then second paragraph maybe 4 lines, and third paragraph sometimes maybe 2 to 3 lines. That's it. Understood. So when examiner assigns marks, examiner will assign marks for each paragraph separately. Sometimes it so happens you must have written a concept very well, but the third paragraph you did not give a solution properly because you misunderstood it, but you gave the concept. Then maybe first paragraph you will definitely get some marks. So that is how. So writing a section or writing a provision always in law will definitely add something to your marks 101%. So make sure you do not ignore sections, and especially sections concepts will also help you to answer all MCQ based questions, because 30 marks out of the entire subject you have got MCQ based questions. So these questions will definitely help you to finish this exam. I mean, this paper, especially in group one, with an exemption marks, that is 60 marks. Okay, so my target is to make sure the students who are writing in the month of May in law, you should get 60. Okay, so let's get into the section. Section 1 talks about applicability. Section 1 talks about applicability. I repeat, Section 1 talks about applicability. Company Law 2013 applies to banking companies, applies to insurance companies, applies to electricity producing companies, banking company, insurance company, electricity producing companies. See here, banking companies, insurance companies, electricity producing companies, and special act companies, unless and until company law sections are inconsistent with their laws. That means you have insurance companies regulated by Insurance Regulatory Development Authority of India. I mean, Insurance Regulatory Development Authority Act, IRD Act 1999, and Banking Regulation Act 1949, Electricity Act 2003. And every company which came into existence through special act of the parliament, they are called corporations or special act. So they have their own acts. That means company law will apply to such institutions, such entities, that is banking, insurance, electricity producing companies, if company law sections are not inconsistent with their law. In the sense, if there is something very clearly in their law, 101% company law will not apply. If something is missing in their law, definitely being a company, they have to follow company law. That is section 1. I hope I made it very clear. Section 2 talks about definitions. So section 2, when you read definitions, normally we use a legal term called clause. So we have got 95 definitions. In your syllabus, 93 definitions are given in C Enter first chapter. C Enter first chapter completely. Some of the sections I divided chapter wise. Some of the sections I just continued. So there's no use because you have to read in an order with the sections. So total 95 definitions we have. Some of the definitions, students who have studied the CA Foundation, they've already studied in CA Foundation itself. So you don't have to worry. So 95 definitions we have. Section 2, clause 1, 2, 3, like this. All right. Some types of companies we have, everything we'll see one by one. So the definitions, exclusively separate class I will take. Let's continue with section, what you call 3. Section 3. Simple, remember section 3. So first of all, to understand section 3, you need to understand how many types of companies do we have right now. So most of the students are thinking, okay, we have got only two companies, private company and public company. Yes, you have got private company and public company. But from 2013, in private company, there's a special category of company called one-person company. Special category of company called one-person company. This one-person company is also a type of private company. So therefore, we can come to a conclusion that there are three companies. Number one, public company. Number two, private company. Number three, one-person company. So section 3, clause 1A talks about section 3, subsection 1, clause A. Section 3, subsection 1, clause A talks about formation of public company with minimum 7 members. Section 3, subsection 1, clause B talks about private company which can be formed with minimum 2 members. Section 3, subsection 1, clause C talks about one-person company which can be formed with one person as a member. So 3 companies, section 3, rhyming, matching. 3 companies, section 3, 3 companies, section 3. All right. Then we have got section 3A. Section 3A talks about if in case any company has run for more than 6 months, if in case any company has run or continued for more than 6 months with less than the required number of members. In case you are a public company, you are supposed to have minimum 7 members. If in case you ran public company with less than 7 members, then post 6 months, all the debts that were incurred during those times, the member who ran or the members who continued company for more than 6 months will be personally liable. for the debts that were incurred during that time. We are not going to make them liable during that time, but we are going to make them liable after 6 months for the debts that were incurred during that time. That is the point you need to understand. So section 3A talks about members. Generally, why this section is clearly given, I'll tell you. In general, in company, members' liability is limited to the extent of share capital unpaid. That means whenever company wants money from you, company can ask only unpaid money. But when company is run continued for more than 6 months, the members or the member, in case of private company, two people we need, but he has run the company for more than 6 months with only one person. That means if you ran the company for more than 6 months, you will be you will be personally liable for all the debts which were incurred during that time after 6 months. After liability starts after 6 months, but the debts were incurred during those 6 months. Understood now? That is the meaning. All right. Yes, that is section 3A. Next, section 4. This is a revision class, so I just want to give you clear-cut clarity as to every section so that whenever concept-related question is asked, you can easily answer that question. So that is my objective. That is my objective here. Then section 4 talks about memorandum contents. Generally, you need to understand these two sections side by side. Section 4 gives you the contents of memorandum of association. Section 5 gives you the contents of articles of association. So when you talk about section 4, we are talking about 6 clauses of memorandum of association. 6 clauses of memorandum of association. Use this acronym, you will be able to remember easily. Nasal C. Nasal, just like for human beings, nasals are very important for breathing. For a company to continue, this 6 elements or 6 clauses are very important. All right. So one is name clause, name of the company. Second one is association, that means how many people have actually started this company. Third one, situation, that is registered office. Fourth one, O, objective, the purpose for which company has been established. L stands for liability, whether it is limited by shares or limited by guarantee or unlimited company, with capital, without capital. C stands for capital. How much is the authorized capital? How much is the subscribed capital? How much is the issued capital? How much is the paid up capital? So on and so forth. Nasal C. That means for practical question's sake, in the material, go in detail. Do not read any other material in the market. My sincere advice, please read only institute material. I repeat, read institute material and come to our conclusions and practice everything that is there in the institute material. And ICAI is giving you such kind of resources where you don't have to search for anything anywhere outside, please. Please, my sincere advice. They have got model papers, they have got revision papers, they have got suggested answers, they have got everything. ICAI is such an institute, is guiding students A to Z 100%. Only thing is you have to start using. If in case you don't start using online classes like this, you attend. That is the only option, right? So section 4 talks about contents of the memorandum. Remember, at the time of starting a company, these two documents are very important. Under section 7, one of the very important document that you have to submit is memorandum of association and articles of association. Memorandum talks about the nature of the company, structure of the company, constitution of the company, principles of the company, fundamentals of the company, powers of the company, scope of the company, business of the company. So every company is expected to act, do anything within memorandum. It's a main document for the company. And articles of association is a subordinate document. Articles of association talks about rules, regulations, how exactly companies run, companies managed, companies regulated. So the internal management of the company is normally explained in articles of association. So if you look at section 5, we are talking about articles of association. It contains rules, regulations, internal management, etc., etc. But one very important thing in your material, they have emphasized more on something called entrenchment clause. So whenever you design articles, you will definitely have a set of rules and regulations based on which company is managed. I repeat, whenever you design articles, you generally, so one more very important thing you have to remember under section 4 and 5, schedule 1, table A to E talks about, will give you model memorandum of association, and table F to J will give you model articles of association. because there's generally three, there are five companies, like company limited by shares, company limited by guarantee without share capital with share capital, unlimited company without share capital with share capital. So overall, five types, five categories of companies we have. So whenever you design articles, you are basically designing the rules based on which company is going to be managed. How exactly company operations are managed by internal people, that is board of directors, and how members will take the decisions in the meetings, etc. So regarding meetings, regarding issue of shares, regarding buyback, regarding cancellation of shares, regarding appointments of people, regarding investments, regarding loans, all these things will be given very clearly in section 5, I mean article section 5. If in case you don't know how to prepare articles of association, you can go to schedule 1, table F to J, depending on the nature of the company. All right. Once again, I'm telling you it is a revision. So that means I'm always having an assumption that you already read this once. And I always have an assumption that you have already understood the nature of everything. I just want to give you an amount of revision last minute wherein you can just remember something and understand case law and write. So what is this entrenchment clause? When we talk about entrenchment clause, entrenchment means to provide protection. When there are rules in the articles of association, if in case members wanted to change, members can definitely change by passing special resolution. Yes, any rule can be changed by passing special resolution. But I want certain rules to be there in the articles, and I want certain rules changed to be very difficult. When company wants that some rules and regulations are to be there no matter what, and if in case since shareholders have a right to change by passing special resolution, let me make the rule change as very difficult. So therefore, instead of special resolution, you can say, okay, boss, to change so and so rule, 90% majority is required. To change so and so rule, 100% majority is required. Like this, you can mention below the rule a clause. So rule number 4, below the clause, below the rule, you can mention one clause saying that change of this rule requires 90% majority, 100% majority, 80% majority, only special resolution, something like this you can mention. So in articles at the time of formation of company or subsequently over a period of time, if you want certain rules changed to be very difficult, I repeat, if you want certain rules changed to be very difficult, you can insert a clause below that section very clearly stating that this particular rule change require at least 90% or 10% majority. That is entrenchment clause. When can I include this clause called entrenchment clause, which provides additional protection to a rule? We can't say you should not change articles, but you can say to change so and so rule in the articles of association, you require this much of majority. You require this much of majority. That is entrenchment clause. You can place this clause at the time of formation of the company or over a period of time. But whenever you happen to insert a clause called entrenchment clause, which helps us to provide protection to certain rules, we are not going to make a rule that rule cannot be changed. We are going to make a clause that this rule change requires this much of majority. That is entrenchment clause. Only thing is communication to ROC is very important whenever you had this kind of clause in your articles of association. I hope you understood. Yes, very nice, very nice. Very don't when you're listening to the class for 20-30 minutes, make sure you don't do anything, WhatsApping or chit-chatting or this, that, etc. So don't do anything. You can listen to this class while eating also, no issues. But don't do mind diversion activities. Okay, that's very important. Next one, section 6. Though I don't advise you to read sections in order, but I advise you to read sections in the concept wise. Since you have already attended classes wherever you attended, this class will help you to have all the sections at one place so that you will not have any confusion. So section 6 says what? Section 6 says, first of all, let us understand background story of section 6. So company is run by three very important things. Number 1, memorandum of association. Number 2, articles of association. Number 3, company law. Number 4, resolutions. I repeat, company management is definitely on the basis of memorandum of association. Is my point clear? Articles of association, resolutions passed by the members, agreements entered by the members, and company law. Understood? Now the question comes, then members of the company or management of the company might think, okay, so we have a memorandum of association, we have articles of association, so we'll continue company based on these articles and so on. So company can decide. But what if they follow articles, but those things which they included in articles is not according to company law? What if they have resolution passed, they have agreement entered, they have articles designed, they have memorandum designed, but what if all these four memorandum, articles of association, resolutions passed, agreements entered by the company are against company law? So this section will come at the rescue of such things. If it says very clearly, no matter what you have in articles and memorandum and resolutions and agreements, the first important superior priority should be given to company law. So section 6 is insisting, saying that no matter what is there in articles, you follow articles, no issue, subject to company law. You follow memorandum, no issue, subject to company law. So over these memorandum, articles of association, resolutions, agreement, which is the supreme or which is the main important thing, company law. So the statement of this section clearly says Act overrides articles and memorandum. Act overrides articles and memorandum. I hope you understood. Move on. Section 7. Section 7 is a very general section in company law. Section 7 talks about the documents that you're supposed to submit at the time of incorporation of company. And especially when you go to www.mca.gov.in, you wanted to float company, you wanted to incorporate company. So there are certain documents that you're supposed to submit, right? There are certain documents that you're supposed to submit. These documents list certain documents, certain declarations, certain kind of information that is to be given at the time of incorporation is generally given in section 7. Is generally given in section 7. Is my point clear? Yes, everybody? Okay, so documents to be submitted. Number one, you have to give memorandum of association and articles of association. Number two, you have to give a declaration by professional CA, CMA, or CS or an advocate stating that this company which is being incorporated has complied with all the rules and regulations. And you also have a declaration given by first directors and subscribers stating that they have not been convicted in any what you call cases before while forming the company. Understood? And they also have to declare that the information that is given by them is true and correct. There is no incorrect, false information. Understood? And details of the subscribers. So declaration by professionals, generally INC 8 you will give. A declaration by this one you will give INC 9. Form numbers also sometimes you have to remember. Go detailed. So what you do when you are reading this section, when you're listening to this class, you always have a textbook. I see a textbook beside you so that somewhere you can pause the lecture and listen to, I mean, read that complete section so that you will have a clarity. Like this, just 24 hours you allocate. 24 hours means daily 10 hours. So 2.5 days you allocate, this company law revision will be over. That's it. That is the simple technique. Read like a Rishi, read like a saint, read like as if there's no tomorrow. This is how you have to read when you're preparing for CA because it's not an easy course. The game is very tough, the battle is very tough, and your mindset is very, very important. You must be 100% confident on every concept. Let them ask anything, you should be able to write. That level of confidence, if you want to have multiple revisions, multiple watching of this kind of classes is very, very important. Then you also have to give details of the subscribers. That means in case of private company, 2 people details are enough. In case of public company, 7 people details are very important. And if in case public company, 3 directors details and private company, 2 director details must be given here. Address for correspondence you must give. And forms like UCINC 32 is generally the application form that is to be filed on online, that is also called Spice Plus. INC 33, 34 memorandum and articles of association. 8 is about declaration of professionals. 9 is about declaration of subscribers and first directors that they have not been convicted in any cases before for the formation of what you call company. Then DAR2 is a consent of the director, whoever has decided to be director, whoever has agreed to be a first director, because directors are usually appointed in first AGM. Directors are usually appointed in first AGM. Until first AGM is there, some people must act like first directors. So they have to give a consent form, that is DIR 2. And DIR 12, the details of the directors appointed. DIR 12 is is basically the details of the directors. These are the forms involved here. So you make sure you just have some reading, some amount of reading related to these forms. So section 7 talks about documents and declarations. Section 7 talks about documents and declaration. When it comes to declarations and documents, make sure you're very clear with the forms. Because you see, in law, you have to make the answer very attractive. So simply knowing the concept and writing like a normal history, sociology, economics doesn't work. Because law nature is this. You cannot say this is this unless and until you substantiate your answer with the help of a section, with the help of a provision. Even in tax, you can't say this has to be deducted, which provision it has to be deducted, which provision this is exempted. Something like this you have to. So tax laws and this law, I'm telling you, make sure you always add one masala here, that is sections, and this will 100% help you to get better marks. But don't write a wrong section. If in case you don't remember a section, at least you write as per the relevant sections in Company Law 2013. But I'm not advising any student not to remember sections in Company Law 2013. I want you to remember sections because you have to prove that you are a very, very tough guy remembering everything in this. That is what required, right? If you want, it's not about passing. The happiness comes only when you get more than 60, because 60 in professional courses, that exemption marks I'm giving you, that gives you such a kind of encouragement to you and motivation. You will even clear CA final with the same josh and same enthusiasm, same vigor and confidence. All right, let's move on to section 8. Section 8 talks about you must have heard about section 8. Section 8 talks about non-profit company. Section 8 talks about non-profit company. So simple, first very keywords. If you see, first of all, you can start either private or public company, and then you apply for license to central government. Then central government will give you a license. The objectives have to be charity, commerce, religion, social service, etc., etc. Science, promotion, environmental protection, etc. All right. So summary, if you see fair, you start any company, either private, limited, or public limited. So the word limited is there when you started a company, right? Then you have decided to go for charity, then you have to apply for central government license. The moment central government gives you a license, it is very clear that the word limited is not to be used. You don't have to use. However, the liability of the members in such company, which was originally started as a private or public company, will remain the same. That is limited only. But Section 8 company has got a privilege that they don't have to use the word limited or private limited beside the name of that company. That is the first point. So license is given by whom? Central government. If in case Section 8 company is doing some mismanagement or fraudulent activities, then central government, after giving opportunity to such company, will revoke the license of the company. The moment license is revoked, three things will happen. Three things can happen. Number one, the moment license is revoked by the central government because you have done some fraudulent activities or mismanagement of the company, our terms and conditions based on which license is granted to you, you did not follow. Is my point clear? Then what happens? You will have to add the word limited or private limited, whichever originally you started. The next important thing, central government might ask you to merge or amalgamate this particular company with another similar objects company. The next very important thing, central government might ask you to wind up also. So there are three important things that you have to remember when Section 8 company license is revoked on account of the fraudulent activities and mismanagement of the company and not following the terms and conditions based on which license has been granted. Number one, it will ask immediately that company has to use the word limited or private limited beside its name. Number two, company may ask this, ROC, central government may ask this company to amalgamate with another similar objects company. When it is amalgamated with similar objects company, all the properties, liabilities, obligations, everything will be transferred. And the third important option, central government might ask this company to wind up and sell the assets and settle the debts of outsiders. And the surplus, anything is there, that will be transferred to another similar object company, if not the fund which is prescribed by the central government. Section 8 company is the burning issue in the country nowadays. A lot of companies are actually starting this Section 8 company. So there is a possibility they can ask you this question. As at least I'm expecting MCQ question. All right. Yes, guys. Next. So next important thing, section 9. In this class, we will finish section 10 sections. Okay. Section 9 talks about effect of registration of company. The moment company is incorporated, what is the effect of company? Number one, company shall be body corporate. When I say body corporate, any entity, any company that is registered in India, outside India, any company that is registered in India, outside India shall be called body corporate. Shall be called what? Body corporate. Am I clear? The next very important thing, all the subscribers, that means until company is registered, the people who initiated the company formation, they shall be treated as subscribers of the company. Two people in case of private company, seven people in case of public company. These subscribers on registration under section 9 shall become members of the company. And whatever money that is due until they pay it is treated as debt. That means at the time of signing memorandum and articles of association, being a subscriber, you must have agreed to invest some money in the company. And until you pay that money, that shall be treated as debt to the company. And section 9 also indicates the moment company is registered, it shall be body corporate, it will be separate legal entity. Everything, all things happen in the name of the company, not in the name of the members of the company. That is section 9. Effect of registration. So my point clear. Next one, section 10. Let's look at section 10. Section 10 talks about effect of memorandum of association and articles of association. There are common sense you apply. The moment company is incorporated, members have given two documents, that is memorandum of association, which talks about name and objective, articles of association, which talks about rules, regulations. So usually speaking, we are not expecting outsiders to follow memorandum and articles of association, right? We are expecting members, that means internal people, to run the company based on memorandum and articles of association. Therefore, on registration, there shall be a binding contract between three people: members and company, company and members, and members and members. Apparently, if something is going wrong, a single member cannot take an action on another member. It is the company which has to take an action. So section 9 talks about effect of registration. Section 10 talks about effect of memorandum of association and articles of association. There's a binding contract. I'm only emphasizing that the members on registration are bound by the articles and memorandum, and company is bound by articles and memorandum. Every member. So no single member cannot file a suit on another member if one member does any mistake. It is the company that has to initiate any action. That is section 10. Awesome, yeah. I hope you're able to understand. If in case you're not able to understand, since it's a recorded class, you just have to pause and go back and start hearing once again. I promise this will definitely help you. Some sections might look very easy for you because you have studied very well, but certain sections definitely will open your eyes and will help you to remember better before you go for exam. And case laws, you will ask them like anything. Section 10A. Section 10A talks about commencement of the business. Commencement of the business. It says just because company has been incorporated, it does not mean you can start operations immediately. So there are two very important conditions you are supposed to satisfy if you want to commence the business. Number one, company has to file within 30 days INC 22 stating very clearly that the registered office is ready for receiving any correspondence. I repeat, INC 22 has to be filed by the company within 30 days stating that the registered office is available for receiving any communication, any correspondence. The next very important thing, within 180 days, see there, within 180 days, company has to file INC 20A. I mean, directors have to file INC 20A, understood, where the money pending from the subscribers is paid already. That means what is the time that is given for members to pay the money which is pending? I told you at the time of subscribing memorandum and articles of association, you must have agreed to invest certain amount of money. You must have invested some money is still pending. And directors have to give a declaration in INC 20A stating that the money that has been agreed by the members or subscribers has been paid fully. So how much is the time? 180 days. 180 days. If you could pay within 2 days, you can start. So unless and until these two conditions are satisfied invariably by the company, company cannot commence business. That's it about 10 sections. Very easy sections, but I'm telling you it's going to be section 11 is deleted. We're going to discuss in part 2 of this series, section 12 onwards. Section 12 to again, let's say another 10 sections will finish because some sections are very bulky. Some sections I have to explain in detail. So it doesn't take much time. All 6, 7, like 60, let's say 148, even if I take 10 classes also easily, whenever you find time, just log in and watch these classes. Please don't forget to subscribe this channel and share this to other friends also wherever they have taken a coaching, and this will definitely help. This is Babu Raipudi, Director of Bricks Academy, signing off. Thank you and have a nice day.